Live from Houston, Texas, the humidity capital of the world, it's time for Money for Lunch, where we feed your brain and your business with supersized portions of business and financial news. Now your host, Bert Martinez.
Hey, everybody. I am your host, Bert Martinez. Let's talk to Emily Frost. She is a labor and employment specialist. Emily Frost is a fifth-generation Texas lawyer. Man, I hope she has an accent because I love a big old Texas accent. Anyway, she's board certified in labor and employment law and handles business and employment disputes throughout the state of Texas. I'm excited to have her on the show. Welcome, Emily Frost.
Thank you, Bert.
All right,
Great to be here.
I see that speaking of social media, our last guest talked about social media. So I want to ask you this: as a board certified labor attorney, can an employer ask you for your password to dig into your social media?
Yes, Bert, they can ask you. In Texas, they
Really?
definitely can. They definitely can.
Wow.
There are other states, I believe California and some states on the East Coast, that are considering legislation that would prohibit employers from asking employees for that information. But in Texas, there's no law that would prohibit an employer from asking an employee for their password. I don't recommend it for a variety of reasons, but you can do it.
Wow, that's interesting. Okay, and let me ask you this, because I'm, excuse me, I'm kind of reviewing some of your information here, and it says here that labor and employment law is one of the most rapidly changing areas, and it's also one of the most costly mistakes a business can make. Why is that?
Well, I think, Bert, that employers, there's just so much out there. There's so many laws, and they're changing all of the time that it's just hard to keep up. And so employers aren't thinking about labor and employment law. They're thinking, how do I run my business? You know, how do I sell my product? How do I provide my service? And so employee issues are sort of they put it on the back burner. And when an employee issue comes up, they just want to dispose of it as quickly as possible. But actually, if they pay a little more attention up front, it can save them a lot of money down the road.
Gotcha. Speaking of, okay, so let me ask you this, because I know that at one point arbitration was kind of, it became the thing that everybody was doing because it was so cheaper. It was cheaper than litigation. And so, me and hundreds, millions of people have signed these employee agreements that had arbitration and have gone through arbitration. Is arbitration still an effective, cost-effective way to go, or is there a better alternative now?
Well, Bert, arbitration, the reality is that arbitration is just as expensive as litigation. And any employer who has arbitrated a case recently will tell you that, because you still have written discovery, you still have to take and defend depositions, you still have filing fees, and on top of that you have to pay the arbitrator for his or her time. But the benefit of arbitration, in my opinion, is that the parties get to control who the decision maker is. Because if you're in state or federal court, you're not going to get to choose what judge you get. You're definitely not going to get to choose what jury you get. But in arbitration, there's a process by which the parties usually have to agree on who the arbitrator will be. And the benefit of that is you can pick somebody who specializes in employment law, and you're usually going to get somebody, unlike a state or federal judge, who's not overloaded with other cases and so has more time to address your case, which can mean a better result. The downside of arbitration in Texas is that until recently, you couldn't appeal an arbitration decision. So if the employer goes in and arbitrates and gets a bad decision, there's no recourse. But just last year, the Texas Supreme Court held that under state arbitration law, if the parties structure the agreements that way, you can appeal. And so what I encourage employers to do is review those arbitration agreements and make sure that they're structured under state arbitration law, not federal, because that's a big difference between the two, and allow both sides to appeal the decision if it doesn't go their way.
Got it. I love it. Okay, Emily Frost, attorney and a labor specialist. Stay on the line. We're going to take a quick commercial break, and then we're going to be right back.
Tune in Monday through Friday here on Money for Lunch, and check out our website at moneyforlunch.com.
Hey, we're back. We're talking to attorney and labor and employment specialist Emily Frost. We're talking about you and your employees, you and your business, and possibly talking about your employer, depending on who's listening. Great information. Now, let me ask you this. The EEO, which is the Equal Opportunity Department or whatever, what is the number one equal employment opportunity claim against Texas employers?
Bert, the number one claim against Texas employers, and this was a surprise to me, I just found out this recently when I was writing a blog on this topic, is retaliation. And retaliation,
wow.
Of course, retaliation claims nationwide make up 10% of the claims filed nationwide. In Texas, they make up 47% of the claims filed.
Oh, my gosh! Oh, wow. Man, so do not piss off your employer. You have a 47% chance that this person may go off on you. Now, so when you say retaliation, what are we talking about in the form of retaliation? Are we talking about sending out nasty letters? When you say retaliation, what does that mean?
Retaliation just means where an employer takes an adverse employment action, such as firing somebody or demoting somebody for complaining about discrimination. So if I go to my employer and I say, hey, I feel like my boss is sexually harassing me, can you do something? And they say, yeah, we'll take care of it. And then tomorrow they call me in and say, oh, by the way, you're fired. That's retaliation.
Gotcha. Okay, so my question is, how can we prevent it?
So with retaliation, I mean, obviously the first thing is don't do it, don't retaliate. But the second thing is you want to be able to demonstrate in writing that you did not do it. You want to be able to show that you didn't do it. And the way you do that is through your policies and procedures. You got to have an anti-retaliation policy. You got to educate your employees about it. And if you do have a complaint about discrimination, you need to do something about it. You need to tell the employee, okay, I hear your complaint. We're not going to retaliate you. We're going to investigate this complaint and then investigate the complaint. And even if your investigation does not, comes out, we don't think that any harassment occurred or we don't think any discrimination occurred, you can still do something about it by requiring all employees in the department, for instance, to go through some additional training. Because when you do something about the complaint, even if it's not, firing somebody or terminating somebody or writing somebody up, the employee feels heard. And in that instance,
right,
they're a lot less likely to bring a claim of retaliation.
Love it. Emily Frost, guys, if you need some help with your business or if you have questions about your rights as an employee, check out emilyfrostlaw.com or TexasBusinessMatters.com. Emily Frost, thanks so much for stopping by today.
Thanks, Bert. Appreciate it.
Tune in Monday through Friday here on Money for Lunch and check out our website at moneyforlunch.com.